Are you ready for us to go?
No.
Yeah, give it just a couple of minutes to let everyone sign in. We're almost there. We're probably only about 10 people shy.
Okay. You'll announce when we're starting.
Yeah, I'll
Minute.
I'll outline the program and then let you guys go. So
Perfect.
we're at 49 participants, so we're getting close to our registration.
I was just excited to tell Ron no.
Don't get too excited.
I said no.
Hell no.
Yeah, yeah, exactly.
Judge, if you want to go ahead and get started, it looks like most everyone is here.
Thank you, ma'am. All right. I want to welcome everybody to this CLE program put on by the Topeka Bar Association Criminal Law Committee. We have some scenarios that we're going to work through this morning with the Never Ready for Primetime players. The folks that have been active on putting this together, I want to recognize. That includes Steve Carr, Ron Wirtz, Tony Mativi, Cease Mariani, Maven Wright, Jessica Dami, Carol Ruth Bromdrake, Judge Penny Moylan, and Charles Kitt. What we're going to do is we're going to put on two different situations dealing with defense negotiations, and then two situations with regard to prosecution negotiations. Each of those situations will be followed by some polling questions that will get some interaction from participants on. We have a chat function that's set up, so we'd invite you to send us questions that you're interested in having us, or a Q&A section, I guess, as well, to send us questions that you're interested in seeing if we could address before the end of the program. Our goal is, of course, to meet 50 minutes of CLE. And if we do that, that'll be my standard of excellence, again, having been met. We'd also be interested in subjects you'd like us to pursue for other CLE programs that are of interest to those of you out there practicing criminal law. So with that in mind, we're going to deal with the first situation of defense negotiations, and that's going to involve Steve Carr as the defendant and his attorney, Ron Wirtz. So we'll turn it over to them.
Okay, Mr. Carr, we've been through through the charges, and you've had a chance to look at the discovery in this case. So I thought it's kind of time that we should discover what our next step's going to be. And I'm thinking that maybe the next thing we ought to do is go check in with the prosecutor and see if they're willing to make a deal.
Why would we do that? I don't want to make any, I'm not going to do a deal.
Well, I'm not talking about you doing a deal. I'm talking about us going and talking to the prosecutor so we can see kind of how they're thinking about their case and what they might be offering. So you know, and I know what we're looking at as we start making plans of trial or otherwise.
I don't care what they're offering. I'm telling you, I don't want you to talk to them because I don't want to try. I want a trial. I don't want a plea of any kind.
Well, you've seen the charges against you. You've got an aggravated robbery and a possession of a firearm after being a felon. This particular prosecutor here that we're going to be dealing with has given some pretty good deals in the past, and I think it'd be good for you to know what position they're going to take. Now, it's going to be your decision, but I think it's helpful if I go talk to him to find out what the offer might be, and then we come back and talk about options.
I don't want you talking to the prosecutor. I mean, first of all, like I said, I either want a dismissal or an acquittal, and I understand that you gave me those reports. I think there's a whole lot that's left out of there, and I didn't do it. And more importantly, I don't want anybody thinking that you're going and trying to get a deal on my behalf.
Well, uh, I most good defense attorneys are going to want to talk to the prosecutor and talk to him about what their position is. And that's all I really intend to do, is to go to them and under the ethical rules, I kind of have an obligation to find out as much as I can about their position, and discussing their position on plea bargains or their thoughts is a good way to do it, I've found.
Well, that may be a
can't
good way
make a
you
deal
found,
without
but I
you.
mean, I just was talking to Frankie Fingers, who's in the cell next to me, and he indicated that, you know, he had that happen once where a guy went to the, you know, defense attorney went to the prosecutor, and next thing he knows, he's doing 20 years in prison. And Frankie's an old guy now, and so I don't want that. I don't want you to go talk to him. I mean, I trust Frankie. I don't want that.
Well, I'd sure like to have you agree that I could go talk to them. We're gonna have to talk about me going talking to him anyway to get any additional discovery there might be. So oftentimes the subject of settlement comes up, and I think it's always good to let them talk. I won't be able to commit to anything without coming back and talking to you. But I think it's a good idea to hear what they have to say, and that's all I'm talking about doing, is hearing what they have to say. So you think,
You keep wishing. Don't do that. I don't want you to go talk to him. I have faith in you. I think you're going to get me acquitted, and I'm going to trial. I have faith in you. Don't go talk to him.
okay, well, if that's your position, then I'll need to go talk with the prosecutor and see if they have any additional information and start looking for a trial date as soon as we can.
Good.
What do you think about that?
I think that's good. You know, like I said, I didn't do it, and I think you'll prove that and get me off. And I don't want any deals. I don't want to do 1 second of anything. I don't want probation. I don't want nothing. I don't care what they're offering. I want to go to trial.
Well, there's a good number of people that say that it's my obligation to do it regardless of what you say, and I respect what you have to say, but the prosecutor is going to bring it up, and I'll come back and let you know how it went. Is that okay?
Sure, but I don't want anybody out there thinking that I'm going looking for a deal.
Okay, I'll be real careful about that, but I need to go talk to the prosecutor in order to keep this case going and go in your direction. And that's what we'll plan on, and I'll be back to talk to you after I have a chance.
Just make sure you tell them we're going to trial.
I'll let them know that that's your position. That'll be our bargaining position, okay?
Okay.
All right,
I'm going to go talk to Frankie, see what he thinks.
talk to you later. Take
Bye.
care. Okay, we're next to hear what comes next.
You're now meeting with Tony. Prosecutors ask you, are we really going to trial on this case? And you're telling him what your client's position is.
Hey, Tony, how are things going on this case?
Well, good, Ron. You know, I actually, this file's right on the top of my desk. You know, I'm getting ready to retire, so I'm going through all of my cases, trying to figure out what I can get rid of. What are we going to do on this one? How can we get rid of this?
Well, I got to tell you that client is pretty strong in his position of saying he really doesn't want to try this case. So, or he wants to try this case. He doesn't want to do any pleading.
Yeah. Blah, blah, blah.
Yeah.
So let's talk about a deal though. What are we interested in here? So this was a bank robbery. He was waiting outside as the getaway driver. Is that right? And he had looks like he had a firearm, and he discharged the firearm. I'll tell you what, I'd really like to get rid of this. Let's amend the robbery down to a loitering for him waiting outside the bank without permission. And instead of the discharge of the firearm, I'll do a littering for the shell casings that he left on the ground. How about that?
So we've got 2 misdemeanors.
Yep.
All right. And what are you looking at as far as a sentence goes?
Is he in right now?
Yeah, he's still doing time. He's going to be almost time served, I think, as long as
Well,
they're consecutive.
We'll just do time served, no paper.
All right. Well, that sounds like a good place to go, but I'm going to have some convincing to do by talking to him. I
Well,
appreciate the offer and I'll get back to you. Okay.
If anybody can convince him, Ron, it'd be you. Good luck.
We'll see what we can do. Thank you. Take care.
Okay, so now the defense attorney goes back to talk to his client who's been talking to his friend in the next cell. Steve?
Steve? Hey, Mr. Carr.
Sorry, I was a little late. I was talking to Frankie.
How's Frankie doing?
He's good.
Well, I talked to the prosecutor and he's really
You told him
pushing.
we were going to trial.
Here.
You told him we were going to trial?
Well, I told him that you wanted a trial and that you were strong and didn't want to take any position other than to make a deal. You didn't want to make a deal. You wanted a trial. You wanted a jury trial. You wanted to see what kind of case he had and make him make a case.
Good. So when's our trial date?
Well, we don't have a trial date yet. He let me know that he's offering to dismiss the felonies in this case. And he's going to offer misdemeanors, loitering and
But wait a minute. I told you not to talk about any offers. I didn't want us discussing no offers.
well, I didn't discuss it. It was what he talked about, and I sit there and quietly listen to what he has. Now, once a prosecutor tells any lawyer what to do as far as an offer or a settlement, I have to tell you what he said and talk to you about a resolution of the case.
I don't want to hear what he said because I want a trial. I don't care what he's offering.
Well, if you were to plead to these offenses, he's offered to have you go for sentencing for time served, and no probation, nothing. You get credit for time served, 2 misdemeanors, and you walk free. That's his offer, and I think you ought to consider that and go talk to your jailhouse buddies about it, because you can walk completely without going to trial. You go to trial as you're presently charged, and you can be looking up to as much as 5.5 years.
But he wouldn't be offering that if his case wasn't completely weak. He knows I'm going to walk out of there a free man with no convictions on my record.
Okay, guys, let's go to Jessica Dami and the polling questions. Jessica?
Okay, so you should have polling options pop up on your screen here momentarily. Your first question is going to be, did the defense attorney, in engaging in the plea discussion with the prosecutor without consent of his client, violate an ethics rule? Responses are yes, no, and possibly. We'll give everybody about a minute here to put in their response, and then we'll look at what the participants think. Okay, can we close the poll and see what our results are? Looks like we have 16% say yes, there was an ethics violation, 43% say no, and 41% say possibly. Let's go back to our
Okay, so our second situation, the defense attorney knowing the case and the prosecutor knows she can get a good deal from the defendant, but the defense attorney does not initiate plea negotiations at the defendant's direction. So here, Ron has done exactly what the client wanted, although they know that he could have gotten a good deal. And they have a discussion after the defendant's been convicted when he learns that he could have gotten a deal, but he's upset with the lawyer following his direction. So we'll turn it over to them for a short scenario, and then we'll move on from there.
Okay, so we've had our trial and it didn't go very well, huh? And you're doing
Yeah, because you didn't do your job.
Well, we had a bad result. but you insisted that I not try to make any deals, and we went to trial.
Well, yeah, but I mean, he offered 2 misdemeanors. Why didn't you tell me that that was what I should have done?
Well, because you instructed me from the outset that I wasn't supposed to even talk to him about it, that it was a telegraph of a bad tactic, and you instructed me not to do it. I did what you told me to do, and even though
I didn't really understand. I mean, I didn't know that I was going to go to prison for the rest of my life.
Well, you're not exactly going to prison for the rest of your life, but you're doing 5 or 6 years. And that's because you refused.
Small guy like me, that might as well be the rest of my life.
Well, that I realize your situation, but you're the one that made the choice. I gave you the choices, and you made the choice, and I honored your position. Consequently, things didn't go right, and I feel like we talked about the possibility it went right, and there's just nothing we can do about it.
But I just kind of feel like you just mailed it in. You were mad that I didn't let you negotiate. And then I don't really feel like I got full representation after that, because you were mad at me for not taking the deal.
Well, sorry you found that out, but you've been sentenced. We took you around. That's the result. If you want to appeal, I'll file the notice and withdraw.
Please do.
All right. So Jessica, our next poll question, please.
So the defense attorney did not seek plea offer from the prosecution at the client's direction, even though the attorney knew there was a reasonable likelihood of a good resolution. Is this an ethics violation? Yes, no, or possibly. We'll leave this open for a little while. Okay, let's go ahead and close our poll. We have 27% believe yes, there was an ethics violation, 54% believe no, and 19% believe possibly. Back to you, Judge.
All right. So that takes care of the scenarios that we'd put together with regard to defense negotiations. Some of the things that come to mind are that with regard to some of these scenarios, it becomes fairly clear that the attorney needs to be making a good record in his file as to the discussions that were had with his client and what was said, and what advice he gave his client and what his client gave him in the way of directions. I think that doesn't take a rocket scientist to figure out that that'd be helpful at a later point in time. Okay, so now we're going to switch gears. And we've got a situation where the prosecutor is talking to the victim in the case about the strengths and weaknesses, and the victim is adamant about having her day in court and making the defendant pay. So we have Karen as our victim and Tony Mativi as our prosecutor. There's Karen, and she's pretty sympathetic today. And there's our prosecutor. Wait.
Hi, Karen.
Hello.
Tell me what your expectations are here.
I want justice. I want justice.
I understand. Tell me what that means to you exactly.
Prison. I want him to go to prison.
Okay.
Forever, for a long time.
Okay. You understand that if we proceed to jury trial like you want us to do, there are lots of risks accordant with that.
Do you see these scars? I have scars. I have scars on my head and scars on my heart.
I'm sorry to hear that. I understand. So the criminal justice system, oftentimes, to get a verdict, we're subject to the ration of a jury, right? I mean, we will present the case to the jury. I'll do my best. We'll present all of the evidence.
Of course, I understand all this. It's
okay,
like TV.
Very good. The defense is going to file motions to suppress. I think we're going to prevail on those. I think all of the evidence is going to come in. But at the end of the day, you never know what a jury's going to do. And unfortunately, sometimes juries want to compromise. Sometimes the way they compromise is they convict on a lesser included offense.
No compromise, no compromise. I understand that means no compromise.
I understand. I understand that right now, the way you feel is that you want to proceed to trial. My job is just to advise you that there are risks associated with that. And
where are you for me? Where are you for me? I hear things. I see things in your office. I see a conference room that has retire cake, happy cake with balloons for you. You retire, you leave, you don't care. You don't care about little people. You
No,
must
Karen,
care. You must have justice.
Karen, I care very much, and I want you to know that I'm going to be there in the courtroom arguing very passionately.
You'll be on boat. You'll be on big fancy boat.
Well, it definitely won't be a big fancy boat, Karen, but trust me, we're going to present this case. We're going to do it diligently. We're going to do it competently. We want the jury to see everything. I just want you to understand that the jury may not do what we expect them to do. Do you understand that?
I understand, but I can't have it. I will not allow it. I don't allow it. Isn't that within my rights? I don't allow it.
Karen, can I get you a glass of water or a cup of coffee or something?
Is it Starbucks?
Yes.
Yes, thank you.
Yeah.
So there you have the initial exchange between the prosecutor and the victim, who is adamant about having her day in court and making the defendant pay. And the prosecutor, knowing the judge and given the charges, given the defense lawyer, having done a thorough case analysis, agrees to a negotiated plea with defense counsel. So that takes us to how that conversation gets wrapped up, and leads us to our first poll question with regard to prosecution negotiations.
Okay, so knowing that the victim does not want to plea, the prosecutor agreed to a negotiated plea. Was the prosecutor, in agreeing to a plea against the victim's wishes, violating a rule of ethics? Yes, no, or possibly? Submit your response. We'll give you about 30 seconds. And let's close the poll. The results are no, it was not a violation of rules of ethics for the prosecutor to agree to a plea against the victim's wishes. And some of you have asked when we're going to get these results. At the end of all the skits, we will start talking about the rules of ethics and really dig into these results. So thank you. Back to you, Judge.
All right, so then the situation's one where the prosecutor, this may sound familiar given the news coverage in some of the cases here recently. Here's a case which involves a multimillionaire as the defendant and a significant number of witnesses, and the prosecutor agrees to place the defendant on diversion without even talking to the victims in the case. So the prosecutor deals the case out without talking to the victims at all. So they never have the conversation with Karen with regard to putting this defendant on diversion on a high profile case. So Jessica, that leads us to the next poll question, please.
So the prosecutor agreed to a diversion without talking to the victim. Do we believe there's an ethics violation? Responses are yes, no, or possibly. Start the poll. Okay, let's close the poll. Our response is yes, 35%, no, 53%, and possibly 13%. Back to you, Judge.
Thank you, Jessica. All right, so the situation here is that in the materials we've put together some of the ABA standards with regard to the defense function and the prosecution function. I'm going to have Carol Ruth sort of go through those pretty much by by title of the rules so that you'll know that those are included in the materials. And some of those may be something that you'd want to consider if you were dealing with the situations that have been reflected in the various situations and scenarios that have played out here. After Carol Ruth does that, we're going to turn things over to Judge Moylan to talk about the ethical rules that are set out in the materials and have her sort of drill down on some of those that may very well bear on the things that we've seen play out with our prosecutor, our defense lawyer, our defendant, and our victim. We're going to wrap up, I think, by asking, depending on how much time we have, by asking our program participants to share with us one or two things that may be useful for the participants in the program to know or to take away with regard to plea negotiations. And finally, I think I've got Charlie Kitt coming, or somebody from the DA's office that's going to share with us 3 points that they wanted to make sure that we covered today with regard to plea negotiations. So Carol Ruth, I'm going to turn this over to you and have you drill down on the ABA standards, and particularly just take people step by step through the materials that are or through the things that are in the materials.
Thank you, Judge. The materials include the ABA standards, the ethical rules, selected ethical rules, the Kansas Victims Bill of Rights, some articles from the KBA Journal, and some case law. Something that I want to add is don't forget that you have colleagues in the bar that you can always run scenarios by and visit with. Younger members of the bar can provide maybe a fresh perspective, and the Ron Wirtzes of the bar, the Jerry Bergers of the bar, can give you some wisdom from their experience. I'm going to focus for just a couple of minutes on the ABA standards. They include the defense attorney's responsibilities in advising the clients and the control and direction of the case. Who makes which decisions? The prosecutor's responsibility in the conduct of negotiated disposition, the prosecutor's obligation in establishing and fulfilling conditions of negotiated dispositions, the defense counsel's duty to explore dispositions without trial, and the defense counsel's obligations in those discussions. To synthesize, I went through each of those and highlighted key language. And as I thought about how to synthesize those for you, I came up with 3 key functions for both the prosecutor and the defense attorney. Investigate, know your case, communicate with your client, with your witnesses, with your opposition, and then document. I call that defensive lawyering. We all know, as we saw here, that victims and clients are very often unhappy with the outcome of their case. And document, document, document. You will be communicating with your client and the prosecutor and the client. You're not going to make any promises you don't have authority to make, and you're not going to make representations to your client that are not well grounded in the law and the facts as you understand them from your investigation. You're going to discuss with the client consequences of their decision and collateral consequences. The best example I have of a collateral consequence is during my private practice, I represented lots of healthcare providers. I had an MD who had 4 DUIs. A collateral consequence of his actions was that the Board of Healing Arts looked at his license. So you don't want a client to come back and say, well, gosh, I didn't know I was going to be in front of my licensing board, or I didn't know I was going to have to do X, Y, Z. So remember both direct consequences and collateral consequences of whatever decisions your client makes or for the victim. And don't lie. Don't lie to the client. Don't lie to the prosecutor. Don't lie to defense counsel. Documentation can occur on a yellow sticky note. It can occur in a journal. It can occur to an email to yourself. Very often you may need to document and give that back to the client if you're defense counsel. And I want to call specific attention to ABA Standard 4-5.2 paragraph E. If a disagreement on a significant matter arises between defense counsel and the client, and counsel resolves it differently than the client prefers, defense counsel should consider, and I would change that to shall memorialize the disagreement and its resolution, showing that record to the client and preserving it in the file. It will serve you well as you move forward. Don't assume anything. This is not the only case you have, and it's not the only case the prosecutor has. So don't make assumptions. Do your investigation, communicate with all the parties and witnesses you need to communicate with, and document. That's all I have, Judge.
Okay, great. I think I jumped the gun because one of the things that I wanted to make sure that we touched on was the scenario that Tony and Karen worked through. Hang on. The scenario that Tony and Karen worked through with regard to where the prosecutor made a deal without even consulting the victim. And we referenced the fact that was something that had happened down in Florida with the Epstein case. And so, Tony, I think you talked about that at our Ends of Court program. Can you bring us up to date or share anything, any other pithy comments about that?
Well, I don't have anything pithy to say ever, but specifically with regard to this. So in the federal system, we have something called the Crime Victims' Rights Act that is, it is binding on us as federal prosecutors. And the most interesting case, I think, about the CVRA, if you want to look at it, is a case from the Southern District of Florida from 2011. It's called Doe's v. US. And it's Doe's as in Jane Doe number 1 and Jane Doe number 2. The site on it is 817 Fed Sup 2nd, 1337. 817 Fed Sup 2nd, 1337. And this was a case where two alleged victims of Jeffrey Epstein brought suit against the U.S. Attorney's Office and the FBI, alleging that they failed to consult with the prosecutors failed to consult with the victims with regard to letting Epstein enter a plea. And the court went over what the CVRA is. Primarily, there are 8 specific rights that are afforded to victims under the CVRA. They are the right to be reasonably protected from the defendant, the right to reasonable, accurate, and timely notice of court proceedings, the right not to be excluded from court proceedings, the right to be reasonably heard at court proceedings, the right to confer with the attorney for the government, which is what was applicable here, the right to full and timely restitution, the right to proceedings that are free from unreasonable delay, and the right to be treated with fairness and with respect for the victim's dignity and privacy. Here, what the court determined as a matter of law that the CVRA can apply before formal charges are filed. The court had to address whether the particular rights asserted there had attached, and if so, whether the U.S. Attorney's Office violated those rights. Here, though, the court found that it didn't have a sufficient factual record to support those findings, and therefore it had to defer ruling on those 2 issues pending limited discovery issues. In the interest of time, there's one more case that I would bring to your attention. It's Jordan v. DOJ. It's a case from the Southern District of New York in 2016. It's 173 Fed Sup 3rd, 44. That's 173 Fed Sup 3rd, 44. And there's a great quote in that case, and it is critical to our system of justice that the government treat the victims of federal crimes with fairness, respect, and dignity. The CVRA requires as much, as does common courtesy and good prosecutorial practice. The scope of the CVRA, however, is not limitless. It, for example, applies only to those directly and proximately harmed as a result of the commission of the federal offense. It is limited in part by what is reasonable, and it in no way may be construed to impair the prosecutorial discretion of the government. So that's sort of the catch-all for us, is that we are still allowed to rely on our discretion, but obviously you have to use common courtesy and good prosecutorial practice in doing that. So back to you, Judge.
All right, thanks, Tony. In your materials, you have the information about the Doe's case, and you also have a copy of KSA 74-7333, which is the state version of the Victims' Bill of Rights. So you might compare those with regard to the federal CVRA that is also in the materials. Okay, so at this point, I'm going to turn this over to Judge Penny Moylan. You have in the materials various ethical rules that we thought might be appropriate. I'm going to let her see if she can't hit the high points on that, and we'll keep things moving from there. Judge Moylan.
Okay, do we need about 5 minutes for Mr. Kitt or whoever from the DA's office?
We got plenty of time. I'm going to let him try and wrap up, unless you want to let everybody take a 5-minute break, and then we'll come back.
No, I want to know how much time I have.
You're in good shape. Thank you.
All right. Thank you, Judge Osman. As some of you know, I used to work for Stan, so I have a little bit of experience in these rules of professional conduct. I would echo what Carol Bonebrake talked about and talking about colleagues, but another also useful tip, I think, is to call Stan's office. I never knew until I worked there that they actually have a great service to the bar. Well, they will take questions from attorneys that call in about ethical dilemmas, and there is an actual exception to the rule under 1.6 that you can disclose information necessary to seek assistance with your ethical obligations. So I thought that was a really, really good resource and something that I enjoyed doing when I worked there. So that first scenario where we have a defense attorney that has a client that says, absolutely not, I do not want to take any plea, I want to go to trial. This is the old dilemma between 1.2 scope of representation versus 2.1, where the attorney has a duty as an advisor to his client. Under 1.2, as we know, that rule provides that a lawyer shall abide by a client's decision concerning the lawful objectives of representation. Specifically, a lawyer has to abide by a client's decision whether to settle a matter in a criminal case, and whether to, settle a matter, and in a criminal case, whether to plea, whether to waive jury trial. I think that also basically is about a client's decision whether or not they, obviously want to go to trial. But in order for a client to be adequately advised under 1.2, it's really about the means versus the objectives. So here, his client wants an acquittal or a dismissal. And I think as a defense attorney under 2.1, especially if you look at those comments there, it talks about that you have to be an advisor to your client, and comment 1 talks about you have to basically give them a lot of information, sometimes unpleasant facts and alternatives. Stan and I did a ethics CLE on the Lincoln Lawyer, and in that case, we have a client that in the scenario where he's basically saying, I didn't do it, I'm innocent. And the lawyer says, all the evidence shows you're guilty, you're going to get the electric chair, you have to take this plea agreement. And so the question we always pose is this a violation? This is a little bit even beyond the scope of what our scenario involves today. Was it a violation for that attorney to pressure the client into entering a plea? And really, kind of we got to the point of not necessarily under the facts of those cases. So here, the question was it a violation of the rules of professional conduct to engage in plea discussions without the consent of a client? And here, under the facts given, I don't think necessarily in looking at 1.2, you have a client that says, I want to go to trial, I want an acquittal, or a dismissal, Mr. Wertz clearly said, I've got to talk to the prosecution about what the evidence is here. And in the course of that, he certainly did not initiate plea discussions. The prosecutor did. And now we know under 1.4, Mr. Wertz has an obligation to communicate that plea offer to his client. So I think when you look at 1.2, 2.1, and 1.4, here, Mr. Wertz was acting within his duties under the professional rules to hear that plea offer, to respond to it, and then provide that information back to his client. The next scenario was where Mr. Carr has said, absolutely do not initiate any plea negotiations. I want to go to trial. And so based upon that information, the attorney does not initiate any plea negotiations with the district attorney's office. I think, again, based upon, as Carol mentioned, one, you want to get that in writing from your client, first of all. You also want to get in writing that you have advised your client whether, that it's really unadvisable to not enter into plea discussions and that they have nevertheless advised you not to do that. I still think you might have a little bit of problem in not at least having some conversations to see what's going on. But I think under the facts of that case, it'd be a little bit difficult under, this is a little bit off, but under 1.4, when it talks about relaying information to a client, it talks about a lawyer who receives from opposing counsel an offer of settlement, a civil controversy, or a proper plea bargain in a criminal case should promptly inform the client of its substance unless prior discussions with the client have left it clear that the proposal will be unacceptable. I mean, we've all heard that if you get an offer, a plea offer, you have an obligation to press that on to your client. And I would stand by that because this comment kind of makes it look like maybe you don't have to if your client's told you ahead of time, I am not going to take any plea offer. But I think an argument can be made that your client has not been properly advised if they have just said a point blank, I'm not going to take a plea offer at all. Again, it's kind of a little bit of gray area. The next is about the prosecutorial scenario where we have a victim who absolutely is opposed to any sort of plea agreement. I think under that scenario, there wasn't really any issues about failure to provide notice to a victim. If we look at the Kansas Bill of Rights for Victims of Crime, it does talk about information and notice should be given to victims. It certainly does not require a victim's acquiescence to a plea agreement. So I do not think that under that, the violation of that Bill of Rights for Victims of Crime is necessarily implicated under the facts that we have. The next scenario is a little bit more problematic, and when it looks like that there was a multimillionaire defendant, I'm assuming is the case there, and a significant number of witnesses, and it looks like basically the prosecutor was trying to avoid a trial in this case, or for whatever reason wanted to give some favorable treatment to the defendant and did not give any notice whatsoever to the victims. I do think this is a problem probably under the Bill of Rights for the Victims of Crime, even though that language of should is used. And so then the next question becomes, how is that an issue under the rules of professional conduct? This issue has come up. I don't know if any published decisions, but I do think the issues that come here when it comes to prosecutors' duties under the Bill of Rights for Victims of Crime under this particular scenario is possibly a 1.7, which is a conflict of interest. I know that sounds a little bit strange, but here the prosecutor's duty is to the state and basically that's their client. But if here there's some sort of interest, some sort of concern about publicity or some sort of favor to a multimillionaire defendant, I do think that it could be possibly an issue under 1.7, conflict of interest. The next possible rule of violation would be an 8.4D, conduct prejudicial to the administration of justice. If a prosecutor has a duty to provide notice to victims and they fail to do so because of concern about publicity or favor to a defendant, then that could be an 8.4D. And then another rule that's kind of come up before, and I don't know that it necessarily would be in dealing with a statute, is 3.4, which basically talks about fairness to opposing parties and to the tribunal. And if you look at 3.4, C, knowingly disobeying an obligation under the rules of a tribunal, depending on notice to victims, etc. If that could qualify under our rules of tribunal, sometimes that rule has been implicated in the past, and we've been talking about court rules, not necessarily statutory rules. I think that's all I have, Judge Osman.
Excellent, thanks. We're getting ready to try and wrap things up. I got a message from Mr. Kitt with the DA's office. He and Mr. Dunbar apparently are trying to get ready for a hearing or a case at 1 o'clock. So he shared with me by email 3 points that he wanted to make sure that we at least touched on. The first one was that prosecutors have an ethical charging standard that must be adhered to. It's based on available and admissible evidence, which can change as a case progresses. And he made the point that that could result in the addition or removing of charges even without plea negotiations, so that things change over time based on the evidence and information that they have available to them as prosecutors. Point number two, if legitimate defenses exist and can be shared with the prosecutor, that could help resolve a case. Some cases will always be in dispute, trials are necessary. However, most cases can be resolved if a legitimate legal defense exists. And then number three, offers from the defense should be made in advance. Just as defense attorneys must confer with the defendant, prosecutors have an obligation to the victims of crime. And he made the note that offers will rarely be accepted on the spot, given the fact that they have to do that. So those were 3 points that he wanted to make sure we shared with participants today. From the perspective of a former prosecutor who's now on the bench, it seems to me that one of the things that we want to repeat here that we talked about in our earlier presentation is the issue of your reputation as a lawyer. Your reputation as a lawyer means everything, and the situation is going to be one that if you've made a representation to the prosecutor that your client is going to accept a deal, or you've made a representation as a prosecutor that you're going to stand by a deal, or you've told the judge that the case is going to be resolved by way of a plea. And in those cases where the wheels fall off the wagon, that's problematic, because people are going to be making judgments about you and your ability to follow through on your agreements based on the things that happen. So that, and I think I'd reiterate the point that Carol Ruth made, and that was the idea of making a record, either an email to yourself or a note to the file or a memo to the file, because if the case comes back on a 60-1507, it sure is a lot easier for me to make a judgment based on the fact that I talked to my client on this day, we talked for a half an hour and we talked about these things, whatever it might be, as opposed to, well, I think I probably talked to him a couple of times before we went in for the sentencing, or we went in for the plea or whatever. So just take that as something that you can take away from the program. We are at 12:51. Amanda, do we have time to take any questions, or do we need to do anything else before we wrap up today?
We can certainly take questions.
All right. So here's the situation. There's a Q&A function at the bottom of your screen. If you have a question, go ahead and log in there. And then what I'm going to ask is I'm going to ask Ron and Steve if they have any final words of wisdom to share with our participants while we're waiting to see if we have any final questions. So Ron, you were a defense lawyer, you were a prosecutor, you're in federal and state court. What one or two things should participants take away from this program on plea negotiations?
You have an obligation to be independent, and to gather information is not a violation of ethics. In fact, it is required of ethics, in my opinion. The fact I go to the prosecutor and see where they are as far as an offer goes, I think I have always played that I have an obligation to do that. The decision's my client's, and he can kick me out and decide he doesn't want to listen. But I need to know what the parameters are, as Judge Moylan indicated, in order to adequately advise my client. And so even if a client tells me not that I can't do it, I'm going to do it. And then I'm going to go talk to him. If I need to apologize for doing it in order to keep our relationship, I will. But I need to know it in order to talk to him. So don't hesitate to gather all the information possible so you can talk to your client, even if it ticks them off.
Okay. Thank you, Ron. Steve, you prosecuted on the as an assistant district attorney and now on the state level. Thoughts from the prosecutor's perspective?
Yeah, I think the words that Tony provided from that case are most poignant, that you need to treat your victims with respect, which means you're informing them of the offers. But always the first thing that I tell when I meet with victims, and I've met with, unfortunately, a lot of them, is that we're going to listen to what they have to say. I'm going to bring them the offer and let them give me their comments about it. But that ultimately myself, and frankly, really in my case now, the attorney general, or when I work for the DA, it's the DA, gets the final say, and they can choose to accept or deny regardless of what the victim's opinion is or isn't. So it's important that I think the biggest thing is establishing that philosophy right away with the victim. And then that way they don't think they have more control than they actually do. Expectations are important to set up right at the beginning. That's it.
Good point. All right. I think I have no indications we have any questions. So I want to thank our never ready for primetime players for working with us on this and for putting this together. The Criminal Law Committee for the TBA is interested in topics that you're interested in. So if you have something that you want us to pursue for future programs, let us know. Tony, anything you want to share now that you're leaving the prosecution function?
No, just thanks to Karen for making my last few days so enjoyable.
Okay. Well, as she gets to
Justice, I want justice. We go on big boat, you eat cake. Go on big boat and eat cake.
on that, I think we're done. Amanda, thanks for your help. Jessica, you as well. Everybody stay well, stay healthy, and stay warm. Take care.
Thank
Thanks,
you.
everybody.
Thanks.